I'd like to mention item 32 and 33, my lord.
32 and 33.
Due to some personal difficulty, I'm not ready today, my lord.
Criminal appeal.
Yes, my lord. In 32, I'm appearing for the respondent and respondent number 2, and 33, I'm appearing for the appellant. I've taken consent from the other party as well.
On the prayer of Mr. Disoki, learned counsel for the appellant in criminal appeal 18 of 2022 and respondent number 2 in criminal appeal 19 of 2022. List this matter after 3 weeks. 2 weeks.
3 weeks, my lord.
3 weeks.
This is an interim order in item 33, my lord.
Interim order passed in criminal appeal 18 2022 shall continue.
All right.
Yes.
My lord, I beg to mention item number 34, your lordship,
34.
on behalf of Mr. T. Tang. My lord, may I pray that the matter may be listed after 2 weeks, your lordship. The counsel for the appellant is not here today, your lordship.
On the prayer made on behalf of Mr. T. Tang, learned counsel for appellant, list this matter after 2 weeks.
Yes, your lordship. My lord, there's another prayer, your lordship. There's an analogous matter arising out of the same FIR, your lordship.
Here,
Yes, your lordship.
criminal appeal.
Yes, your lordship.
List along with criminal appeal.
Yes,
Number
42 of 2022. Much obliged, your lordship.
By please, Lordship. Lordship, I beg to mention item number 4 on behalf of K. Lawland, Lordship.
Item number
4, Lordship. Lordship, both the party are settled for the,
settle
yes,
outside the court.
outside the court.
You have settled already.
No. Process, under process for the settlement.
Mr. So-and-so, learned counsel appearing on behalf of Mr. K. learned counsel for the respondent submits that parties are making an endeavor to settle the matter outside the court. Therefore, he prays that matter will be listed after 4 weeks.
Yes, Lordship. Deeply obliged.
Having considered that the parties are making an endeavor to settle the matters outside the court, come on. Let this matter be listed after 4 weeks.
Yeah. My lord, I beg to mention the item number 23. That,
23.
yes, yeah, my lord, the applicant will to withdraw this application.
Item 23.
Yes,
Criminal petition.
yes.
You are Mr.
Tempahi. My name is
Mr. T. Pahi, learned counsel for the petitioner, submits that he has an instruction to withdraw this criminal petition. Mr. Instruction to withdraw this criminal petition for which he prays for withdrawal. Mr. Praise allowed. Praise is accepted. Mr. Accordingly, the criminal petition is then disposed of. Dismissed on withdrawal.
My lord, one more item, the item number 26.
26.
Yes, yeah. My I have
Withdraw.
taken no. This matter may adjourn and list on 19th of this month.
We'll
I have taken the consent of the
We'll
PP.
see what is there. It is listed for orders.
Yes.
What is to be what order has to be passed? Let us see.
My
Wait for your turn. Yes.
Lordship mentioned for listing tomorrow, my lord. All criminal case pending before this honorable court.
Criminal petition or criminal appeal?
Criminal petition and criminal revision petition as well as miscellaneous application 2016 case. Only they are coming before this honorable court for quashing of the order passed by the learned court below. Just only for that, my lord, consideration of that aspect, my lord, whether is being pending, my lord. Charge sheet has already been filed. Everything is before the learned
Let
trial
us
court.
see list for orders tomorrow.
My lord,
Orders.
it is already in on several occasions it was listed.
We'll see list
It
for orders.
is in final hearing stage
Final, it's not possible.
for tomorrow.
It's not possible. We'll see list for
Fine.
orders.
Diploma.
Your Lordship, may I mention item number 31?
31.
The counsel for the appellant has some personal difficulty. So can it's
There. 31.
I'm for the respondent, all the respondents.
On the prayer of learned counsel for the parties, list this matter after 6 weeks,
4 weeks,
4 weeks. 31, huh?
oblige.
May I please, your lordship? Lordship, I'm here to
Just
mention,
right. On the prayer of Mr. D.K. Devri, huh? Learned counsel for the respondent. List after 4 weeks, huh? Item 31, yes.
I'm here to mention, lordship, item number 20, lordship.
20,
20,
20,
yes, lordship.
yes,
We are supposed to take fresh step, lordship.
we have not taken.
Not taken yet, sir, lordship.
Mr.
T. Pavan,
T,
T. Pavan, lordship. I'm on behalf of senior advocate Mok Pertin, sir, lordship.
Mr. So-and-so learned counsel appearing on behalf of Mr. M. Pertin, learned senior counsel for the appellant, submits that he submits that the steps could not be taken as directed by this court, for which he prays for further 3 days time to take fresh steps. Praise the Lord. The appellant to take steps for service of notice upon respondent number. To
Respondent
take
number-
fresh steps upon
Respondent number 2, lordship.
respondent number 2 within 3 days. The on such steps, registry to issue notice for service of not issue notice for service, issue notice to registry to take registry to issue notice to respondent number 2. This the matter after 4 weeks.
Obliged, lordship.
May I please, my lord?
Yes.
I beg to mention item number 27, 29 with 30.
Right.
My lord, in this case, parties are trying to settle down outside this court. So my lord may be given some more weeks.
Mr. Your
My lord, di Pangu, behalf of Opada,
D
Pangu.
so and so, Mr. D so and so learned counsel appearing on behalf of Mr. Opada, learned counsel for the respondent Clement
Respondent, my lord.
respondent Clement submits that parties are making an endeavor to settle the matters, to settle the matter outside the therefore we prays for adjournment of the matter for to another 4 weeks.
Yes, my lord, 4 weeks.
Having considered this submission, let the matter be listed after 4 weeks, so as to enable the parties to make an endeavor to settle the matters as submitted. As
Right.
submitted, yes.
May I please, your lordship?
Yes.
Because on the last occasion, your lordship, when issue arose as to whether
Yes,
after coming into effect of the
Yes.
BNSF, whether the new provision will be invoked.
yes. Yes,
Offense was committed in the month of March 2000.
what about these other matters, Mr. Atta?
In that case, lordship,
What is the bail matters?
Matters are supposed to be listed today, but your lordship, perhaps it will listed tomorrow because of
Tomorrow.
the order that it is written 8/7/24.
What is this? What is this? It should be 7/8/2024. 8/7 is gone.
It is written 8/7.
I think it is corrected immediately on the same day.
fix on tomorrow, lordship, another,
Huh?
fix on tomorrow, lordship, another matter. Maybe taken up tomorrow,
No,
lordship.
it's okay. It's very simple. The same thing. In this case, it's a criminal petition filed under the New provision.
Yes.
Yes,
Same
but-
thing.
But incident prior to the implementation of new.
Yes,
And
this,
according to the coordinate based judgment, your lordship, it has to be invoked under the new old code only.
yes, that's why this has been fixed today. It's same thing.
No.
This is,
Your lordship, the other,
see, in other case, bail matter,
Same issue.
application was filed 438.
Same issue, your lordship.
Yes, here the petitioner has filed a petition, this
Under-
criminal petition under the new act.
Yes, your lordship.
So same thing.
Yes,
Other-
issue is same, issue is same,
Huh.
issue is
So
same,
we
yes.
can hear it today.
Yes, your lordship, the amicus were appointed by this court, your
What
lordship.
what are they?
Since actually this morning also the one of the amicus called me, but because of the non-listing of the other matter, because they were appointed in the particular case, your lordship.
It's okay, we'll hear them. You argue. What do you say? You argue in it. Why you have filed in the new act? Under the new provision, under BNSS.
It's because lordship, after coming into force of the new act,
Ah,
it has to be filed in,
why?
because, the criminal procedure code already has been repealed, lordship.
Ah. So what about the sections, once that IPC is also repealed? You have filed this under section 528, read with section 428 of BNSS.
And lordship, the provision of section 482 of CRPC and 5.
You are Mr.
P. Gogoi, lordship.
Huh?
P. Gogoi, lordship.
Yes. What is the section? You have not mentioned the section of the offense. 138.
Or we have challenged the proceeding of 138, lordship.
Yes, where it is. You have not mentioned anything. CRNI case 2 of 2024, that's all. It was initiated, file, when?
It was initiated on
Yes. Where is the order? You are challenging. Which order?
order is lordship, page, Annexure 8, 124, lordship.
124.
Last page of the petition.
Yes, before the coming into force. 138.
Lordship.
Same thing, this has not been repealed. So according to you, it has to be in view of the new, it has to be come into force.
Lordship. And
No, it has to be filed under 528 instead of 482.
lordship,
Why?
lordship, for 482, section 482 and section 528 of BNSF are identical and same, lordship.
So therefore, it is to be, since it has come into force on 01/07/2024, it has to be, application has to be filed.
And lordship, one judgment object, lordship,
Whatever the next is, let us see. Item 2.
We also send.
This is old one. This is filed under all that. 482 CRPC. All right, you are relying on the decision of the judgment of the order of the coordinate bench of this court. So 482. He is saying that it should be, of course, yours is. What is the offense under IPC? Okay. Then third, item 3. No, this is new one. Yes, this is also 528.
I'm next to bola pare. Mo pa na. Loye ba?
Okay, this is 528. Yes. Yes,
Lordship, another matter fixed on tomorrow, Lordship, on that.
it's all right. We'll take it up today.
Lordship.
You make your submission.
One
Well,
judgment,
the
Lordship,
judgment which you are like.
one judgment, Lordship.
I'm sorry for intruding, my lord.
Yes.
The cases in which we have been appointed amicus curiae is listed tomorrow. We'll have to argue tomorrow about that case.
No, in fact, it is listed for today only. I don't know why this has been wrongly typed or something.
We have not brought the judgments or anything since it was not listed today.
This is a criminal petition, same thing. Some of them, item one, new act, BNSS, they filed. Of course, it is under 138, NI Act.
Can we make
And
our submissions tomorrow because since the order it was reflected 8, so I did not bring anything.
Who has typed that? Of course, it's my fault also. I've signed the order also. Why? I remember 7, 8.
I also got confused because of that, because I remember things.
Yeah, 7, 8.
Order it was 8.
Yes.
So that's probably why.
Since those methods were fixed today, therefore these methods were fixed.
Yes.
That has been listed here.
So
only.
I thought maybe I made a mistake.
So what is this judgment?
In this judgment, Lordship, says that, in the last part, with what emerged from the above in the context of this case, that an appeal filed on or after 1/7/24 shall be governed by the procedure provided under the BNSS, not by the provision of the Code of 1973.
This Kerala High Court,
Lordship,
Kerala High Court,
Lordship.
yes. You make a submission, it's okay.
But I will, if I have to assist your lordship, I have to be better prepared, my lord, not in this manner. Because I saw the order,
why-
my letter
why-
sent me the order.
Going into the merit.
No, only on that.
You might have gone through perused the judgment order of this coordinated bench of this court
That I have.
and the Rajasthan High Court,
Yes.
and then you have to interpret. I mean, make a submission
Yes,
531.
based on the, not only 531, my lord, even section 4 of the new act. And by referring to the old act, I will have to make submission. So that is the difficulty.
That case, what is to be done? We'll hear you tomorrow.
Yes,
You
yes,
make your
yes.
argument now.
Yes.
And we'll, since learned advocate general is also,
Yes.
whoever is, I mean, ready, you make an argument today.
I will do my part if necessary, my lord,
Ah.
tomorrow.
Since learned AG is there, we'll also take the assistance.
Only difficulty is I have to be in Guwahati tomorrow.
No, so far as this present petition is concerned, wrongly, I think there's a wrong, I mean, the date has been put in the order. There's no difficulty, but then the bail 438 cannot afford to.
Yeah, I appreciate that.
You may.
That means your lordship will allow me some time or let me go through.
Take it. You are ready?
Yes, I would say, Your Lordship, referring to the saving clause, it may be read along with the section 4 of the new code.
Yes.
Section 4 has to be interpreted, Your Lordship, need to be interpreted.
No, that is, you make your submission.
Yes, Your Lordship.
If you think that the once for interpretation of section 431.
Yes, Your Lordship.
531, it has to be read along with section. You make your submission, will determine. You cannot compel me to read other sections also.
Yes, exactly.
We'll look into it.
But if Your Lordship, the other matter regarding the same issue, if the same will be decided tomorrow, then it will be better if the.
No, we'll hear you.
Okay, Your Lordship.
We'll hear. After some time. At least we'll hear Advocate General. Because he'll not be here tomorrow,
Okay, Your Lordship. Then after pass over.
after some time.
Yes. Item number 3 also same, Your Lordship.
No, item number 3 is
Even new provision has been
new
invoked.
provision, okay.
Yes.
1, 2, 3, huh? It's already mentioned.
But I just, can be taken up next week.
You have been terminated.
Yes,
Is there a
no,
interim order
No.
operating in your favor? Huh?
no. But we speak
What about
about
the affidavit?
affidavit has come, my lord. Affidavit has come.
Has it been incorporated what the court
So what,
wants?
in fact, what they're saying
Court
is,
had said why you have been allowed to continue,
Yes.
even if your
that
appointment.
affidavit is not there. That
Court had
affidavit they have
directed to
not
bring
filed.
on record that.
That they have not filed.
Where is Mr. Tagu?
But the issue, my lord, fake remains, I was allowed to continue. That is why I was terminated.
But then unless it is modified,
Yes, yes.
court has directed.
Uh,
Otherwise, we'll help them for some time. Where is Mr. Tagu? Anyway, next week.
Next week, my lord, judges are also not. That part they have not filed.
I
Earlier, Mr. Jamo was appearing.
thought we can dispose of the matter today.
Would have, my lord, in fact, in the affidavit, they are saying that if there has been a violation of principles of natural justice, that we are ready to do that.
Ready to
They
do it.
have said that.
Your claim is that the provision under which you have been terminated provides for principle to
No,
hearing.
because they have relied on that provision. That is why I am saying.
Which also-
Otherwise, what I am submitting is, without any departmental inquiry, they have done it. It's a stigmatic order. At least they would have given me an opportunity, madam. Based only on the police report they have terminated.
But you are only contractual employee.
Even if there's a contractual employment, I have judgments on it. That's why next week, even if contractual, there is.
On the prayer of heard Mr. Deepang in London counsel for the petitioner. Non appears for the state respondents. Mr. It is noticed that the.
Tagum sir is in other court.
Okay, so appears Mr. Arko appears for state respondent on behalf of Mr. Tita, standing counsel. Mr. You have not filed what the courts want. You have not filed the affidavit. You just apprise him.
I will tell him. He may not be aware, in fact.
Yes.
Mr. Jamo.
It's the order of this court.
Yes,
Why
I am
the-
aware.
you have filed the affidavit, but then the court want that why you have allowed him to continue even after the lapse of contextual period. That you have to.
That is the thing they are doing. Everybody will go in the case.
Okay. Next week, huh?
Well, all right.
Much of.
Item number 6. Yes.
Respondent number 1 and 2 haven't filed affidavit till now. So
Who is respondent number 1 and 2?
land department.
Where's the impugn order?
It's in page number 44.
44.
Seventy-six. 76 is the impugn order.
Promotional. 76.
Yes,
Initially, notice was issued.
yes.
Yes,
And he has filed a writ petition 163.
yes. Earlier he was fine.
Then this petition is against this eviction order.
His impugn orders.
Yes, madam,
Yes, Your Lordship.
what is your right?
Actually, I am staying in this land.
Doesn't
to-
matter, it's a government land. Are you disputing? It's your private land? Is it
It's-
your private land?
But they haven't proved that it's their land till now.
They don't have to. First, you have to establish is it a private land?
It's not, but till,
Just because they are staying over the land, which is a government land, admittedly, and you have applied for the allotment, it's up to the government. Until the time the right is conferred to you. I mean, if you, any right is accrued to you, cannot.
yeah, I have applied for the land allotment. but
Doesn't
they
mean-
haven't
doesn't
granted.
matter. They may consider, they may not consider. Who's your senior?
Sunil Mao.
Are you argue? Argue the
I'm
matter.
not ready. I'm not ready.
Why?
I have not prepared well. Maybe
What's
given,
prepared here?
maybe
It's
next week.
admitted it's a government land.
But I haven't
You
gone
are
to,
staying over the, you are encroaching the government land.
yes,
Of course, you have applied for allotment.
yes,
It's up to the government
yes, sir.
whether to allot it or not. That is not a matter of right.
Maybe next date.
What is your right?
Since 2002, 2000, I am staying there, but they haven't,
You may be there for so many years.
and I have
Let's
already,
remember it's a government land.
yes, Your Lordship. I have already
Are you
constructed.
disputing that it's a government land? No.
When I have submitted the land allotment application, they haven't replied anything for that also. So that is also one.
They don't have to. Even if it is allotted,
Yes,
they have the power to cancel it also, revoke it also. No right.
next date will be given for the argument.
Third MS
Sonam Somu.
learned counsel for the learned counsel appearing on behalf of Mr. Esmo, learned counsel for the petition. Submits the matter may be listed next week
Yes, Lord.
for final disposal.
Yes.
On which date her senior, Mr. Esmo, shall argue the matter. Mr. Next, Mr. Who is first, 1 and 2?
1 and 2 is land management.
Yes, then
Land
you-
council. 3 and 4.
3 and 4. Then you? 5 and 6. MS Arbasar. Then State Council appears for respondent number 2 and 3.
3 and 4.
3 and 4. And also Mr. And Mr. E. Pitcher for respondent number. Then standing council. Yes. For 5 and 6. Then standing to RD. Yes. For respondent 5 and 6. Mr. The challenge made in this two these petitions are the notice of eviction as well as the eviction notice issued to the petitioner as the petitioner has encroached upon the government land at Changlang.
Yes.
Changlang district. That's all.
Much.
Let this matter be on the prayer as prayed for. Let this matter be listed after a week. Which
Yes.
date? 13.
Sorry, Your Lord.
13.
Yes.
1 list on 13. Will dispose of all these matters were unnecessary. Okay. Yes, sir.
I am extremely sorry, Milad.
Yes.
I misplaced my brief Misplaced in the sense, my lord, I kept in another car. The driver has taken the file yesterday for
Yes.
maintenance in Guwahati. My lord.
Yes.
Can they accommodate me for a week, my lord?
Who appears for the respondent?
My brother Pangin is there.
Yes.
Only for 1 week, my lord. Interim order asset, my lord.
The whole proceedings are actually totally chaotic. Interim order was initially passed against persons who were not even party to the suit. Anyway, madam, since my lord,
But the maxim you are trying to invoke is not applicable. Are you saying that the respondent the person who has passed the order is also a party to the
Yes, he was part of the proceedings, earlier proceedings.
in the Keba,
Kebab,
not before the
not before.
okay
But he has a personal interest there.
Nemo Judex
Yes, name was there.
on the prayer of Mr. Tititara, learned counsel for the petitioner, appellant, who submits that he has misplaced his brief, comma. Let this matter be listed on. When after 2 weeks.
my lord. 2 weeks. Brother?
After 2 weeks.
in that case, after 3 weeks, because from 19, I will be out of state.
After 3 weeks,
Interim order may be continued, my lord.
Mr. Deepang, counsel for the respondent, is also present. Interim order passed earlier shall continue.
Much obliged.
Chaotic order. Yes.
This is for quashing, your lordship. The FIR has been lodged for the offences committed under Wildlife Protection Act. And as per the provision of Wildlife Protection Act, the complaint has to be filed, not the FIR. And it has been stated by this honorable court, your lordship. And service has been perhaps completed. So, madam, we fixed for hearing. The other side is not present today.
Non appears body. Any records were recorded?
The CD is with record is with this honorable court, perhaps, your lordship.
It's here.
Yes, your lordship.
Record is here.
CD is there.
CD is here.
Yes, your lordship.
Okay, okay. Non appears for the petitioner on court. Mr. T. Telan, NSMPP is present. Next para. The case diary
Yes.
is received. List for hearing after 4 weeks.
All right.
Meeting को बुलाओ तो receive.
Yes, where is that judgment? Recent judgment.
That matter I have not been able to find out. Yesterday also we
Of
tried.
course, that is on its facts of that case. But then I think whatever it's a reiteration of earlier orders, earlier judgment. Normally it should be from the date of DPC.
It is not there in SSC online also.
Your claim is that since your seniors have been granted promotion with effect from the date of their officiating, you should also be. But if the law doesn't permit, is not it? How you can claim?
My lord has
Just
already.
because
My lord has already dealt this matter.
because yes,
65 pages judgment, my lord.
maybe where is that? Where is that?
Para 45 to 55, my lord.
Maybe
Because, my lord, the same engineering judgment.
I may regret this judgment.
But
No appeal.
no appeal. my lord. Unless it is not cured, this is a law now, my lord.
Okay, we'll admit it's fixed for hearing. Let us see. All right.
But there is some
What is
urgency.
the recent judgment of the Supreme Court? You bring that.
No, but that 2024.
No, no,
No,
no. Only around 10 days back.
Yes, last week.
But
was-
it's not in the
Last
SEC
week.
also.
No, but
By Justice, Honorable Justice Nagaratna. And
I think it was by.
It's not available in SEC
No.
online.
Ujjal Bhuya was also there probably in that case.
In any case, this case.
No, my lord, what will happen is there is a OM.
yours is very simple.
No, there is OM.
You were appointed
Yes, my lord.
on officiating basis.
Correct, my lord.
Thereafter, your service was regularized by DPC.
After 14 years.
Yes, maybe whatever. Then the
And the similar-
authorities has said that
The similar-
your regularization or the promotion shall be from the date of DPC. Whereas your seniors in earlier DPC or in earlier batch, they have been given the privilege of retrospective, I mean, from the date of officiating promotion.
Officiating
That
promotion.
is your case only.
Yes. And then
Whether
my lord,
your law supports it or not. Why you are agree? Why you are?
Because
why they are part?
if they are, the prayer is allowed, they will march over us. I'm
You are
direct recruit.
direct recruit.
13 batch,
When did you?
2013.
13 batch. My lord, the government affidavit is very loud and clear.
2013 and you were appointed on promotion?
No, my lord,
7,
on,
8, 9.
my lord, 94.
Before you,
No,
before
no.
you.
My lord, my,
Before you-
officiating
before your
promotion,
office. Yes.
my lord, I was we were appointed in 94 one. Martho Kamgo was appointed in 94. And
Yes,
rest of the petitioners, another six of them, they were appointed in 1997 as a regular junior engineer in the power department. Now DPC was never held. In the meantime, after 11 years, the DPC was held, and in 2002, my lord, 2002 and 2005.
I think
Or-
I have dealt it somewhere in.
Yes, my lord.
Para
Para 45, my lord.
45.
For para 45. My lord, kindly come to 46. 46 is the best. This court is not oblivious of the settled principle of law by Honorable Supreme Court in a series of decisions, including the above cases, relied on by the parties that a promotion takes effect from date of being granted and not from the date of occurrence of vacancy or creation of the post. However, with utmost respect, this court is of the view that there would not be a complete bar for consideration of promotion, regularization from the date of ad hoc promotion, particularly where the incumbent is promoted on ad hoc basis on clear vacancy and allowed to continue without break with all benefit of that post, being eligible in due to delay in conduct of DPC for long period of 14 years or so. The delay on the part of DPC in convening its meetings should not result in a prejudice to the petitioners who were eligible for promotion and ought to have been promoted, but were not considered with reference to the year in which the vacancy arose. Now here, in the paragraph 3 of the affidavit in opposition by the state respondent 2 and 5, they have clearly shown that the vacancy for direct promotion was exist till 2012. That's why other day I made a submission that my brother's Pangin's client will not be affected, my lord. 13. 2012, there was a clear vacancy.
I mean, so they are not.
You might have gone through this
No, my lord.
wrongly or rightly.
But I will replace reliance on this or Supreme Court judgment.
All the judgments were right here in this judgment.
In any case, I
Reiterate.
will rely on Supreme Court judgment and I will rely on facts.
Let me
That
place
is
my
all.
lord in this case.
My lord is hearing
I'll
today.
not take too much of time.
15 minutes I'll take, my lord. Only 15 minutes.
How much you will take?
I will have to show the total facts.
I'll
The whole premises, in my humble understanding, is misconceived.
Then in that case, let's next week,
my lord, I,
Tuesday.
my lord, I will have to travel out, my lord.
Then when?
Just anytime, my lord, just, that's why like I fix it today, my lord. And despite not keeping well, I have come, my lord. Because I made a promise to my brother Pangin that I'll come, my lord.
Then we'll take, because to hear you, it will take time.
No, but I'll take only 2-3.
But he'll take all day.
I don't think so, my lord.
Not the whole day, but quite a.
Say 40 minutes, my brother will take, I'll take 15.
That will depend.
Next week, you will not be here. Are you here
Where is Gam?
next week?
To see. Gamkin Tanai, I used to see that.
Because there is no urgency in the matter, that's why I'm saying. You are already promoted.
No,
You are in the promotional post.
promotional post, but then
Are you working as AE?
I am working as a AE, but if it is given from 2024, I will be greatly prejudiced because the direct recruitee, they will march over me, Milan.
That is your ill luck.
No, that is what, Milan, I am making a request. This argument, no?
Next week we'll dispose it off.
No.
You agree to
I no. Any date. I can
Right.
reveal.
Milan, I'll make an attempt on 13.
13
13.
on the prayer of learned counsel for the parties. Mr. Titi Tara, learned counsel for the petition, and Mr. Deepang,
5 to 24.
so respondent number 5 to 10. And also Mr. L. 2, 3, 4. Learned counsel for the power department. This matter on 13/08/2024. Final disposal.
In my notice.
In the meantime, you find out that.
Yes, we have been trying to find out.
Get it.
No, Milan, that actually that NR Parmar was overruled in Mega Chandra case and Mega Chandra case.
I don't know.
No, NR Parmar case.
Sir, we'll hear you on that.
No,
On 13.
then thereafter that one judgment has come after Mega Chandra, then it was referred to a larger bench, but the reference has not been decided.
So there is no bar.
There is no bar.
There is no bar.
There is no bar. That is one thing. And let
In
us
fact, the Supreme Court is heavy on the High Court.
Yes.
Just because it has been referred, a reference is pending, you cannot
that
refuse,
1986,
refuse
that
to
1986 OM.
refuse to determine the matter on its own.
And here also, my lord, in my case also, that cabinet decision and all other thing, my lord, 2022.
But on 13, I would
Yes.
like to have that.
I will try to find out.
I'll find out, my lord.
It's not available on SCC online. That is the difficulty. I will ask
you
somebody.
get it from there.
I'll collect it.
There is a SCR now.
ACR, yes.
SCR.
SCR.
No, I have printed out that judgment, which was delivered. But again, somewhere I misplaced it.
It goes against you, therefore. It is against you.
No.
Even if it's against you, please bring it.
It is totally, the fact is totally distinguishable.
Maybe.
Here, my case is totally distinguishable, my lord.
Maybe, but then please bring it.
The government affidavit is loud and clear.
Okay.
And my brother Pangin has to
Thank you.
deal with the government affidavit.
Okay.
Oh, since that has been submitted, my lord,
30.
the annexures in the writ petition and what the affidavit further content, maybe the records will be required.
Okay.
Your lord
Then
will
we-
make an endeavor and.
You'll produce the report. Immediate 13, we have enough time. Today is 7.
Report for Melody. Report of Melody.
No,
Department.
instruction they have said that records.
Especially regarding when these vacancies arose. Because in their affidavit,
No, you further add that the learned counsel for the petition, the respondent, learned standing counsel, Mr. L. Permes will produce the report.
Your instruction be there.
whatever is there.
Record, my lord,
How
issue
this
is
affidavit was filed?
filing of affidavit, my
No,
lord.
no, records relating to entire matter, how, when they were promoted on officiating basis and
Again, which
and
vacancies
till
they are being
till
promoted
till
now.
that.
I am Budaya.
Because both of them have a tough
No, my lord, here only they are challenging on DPC, my lord. So, of the DPC, I can place.
No, he is claiming that he should be promoted from the date of his their officiating or ad hoc promotion, which this court has already allowed in some other maybe correctly or wrongly or rightly.
No, I unable to identify who is record, my lord. Yes,
The records pertaining to the officiating promotion of the writ petitioner as well as the
Date of appointment of the private.
no.
I had
The-
that
the,
appointment is there in the exemption.
And DPC.
if my lord, allow my lord,
Pertains to appointment of the petitioner on officiating basis as well as the DPC. That's all.
it would be better, my lord. Yes, I have annexed some documents, my lord. My lord will kindly, I have annexed DPC
You
twin.
produce whatever records is there, these two,
Also, you bring that,
next.
the Bangil's, like.
Yes,
Lordship, I'm appearing on behalf of Mr. B. Taba for
Yes.
petitioner.
uh,
Lordship, the conducting council is out of session. Next date may be given, Lordship.
records is there.
Yes, POCSO Act. And they came for settlement.
Record is there. Scan copy. It's okay then. There's no stay. There's no interim order.
On no interim.
No interim order.
Yes, Lordship.
Yes. MS Shoaib, London Council, appearing on behalf of Mr. T. Taba, London Council for the petition press. That matter be adjourned for another 4 weeks. Mr. G. Tado, London Prison PP is present. The next para. Scan copy of the report is received. This is after 4 weeks.
Obliged.
Item number 12.
May I please, your lordship?
Yes.
Lordship, in this case, respondent number 10, 11, and 12 has been newly impleted, my lord. On newly impleted respondent number 10, 11, and 12, my lord. My lord, they instructed to file, my lord, the affidavit, my lord. So therefore, my lord, may I have my lord, 4 weeks time may be granted. In the meantime, we'll
You are
file
for respondent number 10, 11,
10
12.
and 10, 11, and 12 also. my lord.
Or Mr. VP Chair, London Council for the petitioner. Mr. M. Kato, London Council, London DHA, press for and granted 3 weeks time to file.
My lord.
affidavit.
Development.
Mr. Soenso, you record your presence. I read London Additional Senior Government, and then correspondent number, state respondent. Have you filed? Yes. You did. Why so big? What is there?
Challenging for watching the affair, undated affair laws on dated 15/11/2020.
Yes.
And subsequent non-bailable warrant was issued, proclamation was also issued by
Yes.
dated 28/11/2020
Yes.
and 21/9/2023.
Hmm.
And according to 25/9/2023.
Yes.
This is the order where I have challenged this by the honorable court
Yes.
for watching and also stay as said order.
Hmm.
in this, by this honorable court on dated 24 or 30/4/2024, leave the matter after 3 weeks on a date to be fixed by the registry. In the meantime, the petitioner is given liberty to bring the charge sheet on record by way of additional affidavit.
Yes.
But I have applied for CTC copy before this honorable court, Guwahati High Court. But registry had returned the CTC application for me because they have informed that the LCR is in before this honorable court, but registry is not able to search the search copy to me. And then it informed me to copy apply before JNHC UPA. Accordingly, I have applied for JNHC UPA search copy. But JNHC also UPA also stated me that as the case is not cognized, so they are not able to furnish the search copy to me. And hence,
what is
those search sheet have received, but not matter is not cognized.
Recognized?
And accordingly, they are not able to search the search copy to me.
Recognized?
Not cognized. Not cognized.
Okay.
By JNHC UPA.
Cognizance has not been taken.
No. So I'm not able to file additional affidavit before this report. And in the meantime, it will not interfere by this court interim order. Pay for interim.
You are praying for interim.
Yes, Lordship. Stay order dated 28/11/2022, 21/9/2023, and 29/5/2029 annexed H, I, and J. G.
You file an application to that effect that as per this order of this court, you apply the certificate for compliance because the cognizance has not been taken by this, so they have informed that the copy of charge sheet cannot be given.
Yes.
You file that, then we'll consider. Or Mr.
G. Puka.
G. Puka, learned counsel for the petitioner. Not Mr. G. Puka, learned counsel for the petitioner, submits that he may be granted some time to file an affidavit to the effect that affidavit like he's placing on record that the charge sheet as the charge is to be produced as directed by this court will not be obtained. As the Court of Learned JMFC has informed that the copy of charge sheet cannot be furnished, supplied as the cognizance is yet to be taken. That's all.
Yes.
List after 3 weeks.
Your Honor, the leading counsel he's from Assam, so he couldn't come to appear before this honorable court. And I've taken the consent from the other parties too, Your Honor. The counsel H. Barwa, he's from Assam, Your Honor. So
does it matter? Why? If he's from Assam, what should we do?
Due to the medical reason, personal difficulties, he couldn't appear for his court. Due to his personal difficulties.
He's court petitioner.
Yes, Your Honor. And I've taken consent from the other parties also.
What is the matter?
The matter is challenging the order passed by the civil judge, Lord of Divine Bail, Your Honor, whereby the present petitioners in this CRP, his petition was cancelled, rejected without a hearing. So.
Mr. Your name, please?
H. Tai.
H. Tai, learned counsel. Appearing on behalf of Mr. D.K. Gupta.
H. Barwa.
H. Barwa.
Yes, Your Honor.
No, learned counsel appearing for the respondent, petitioner. You are also in the matter.
Yes, your petitioner.
That means that the leading counsel, Mr. H. Borwa,
Yes, Baru.
is having some personal difficulties today, for which he prays for listing the matter after
16th of August, Your Honor. 16th of August,
will not fix the after 2 weeks.
2 weeks. Oblige. Interim may be continued, Your Honor.
Prayer is not list the matter after 2 weeks.
Yeah, interim order may be continued, Your Honor.
That was the message.
Oblige.
Yes, we'll see this 1, 2, 3, 4. 1, 2, 3.
Well, I have hurriedly gone through.
Yes.
There are several conflicting judgments. And this is a matter, perhaps in my humble understanding, this will require some amount of consideration. I have seen that there are conflicting judgments of Patna High Court, Punjab and Haryana, Rajasthan. All judgments are, somewhere it is being said old act, somewhere it is being said new act. And one aspect I must point out to your lordship, Supervisor Kalot. Your lordship will kindly have the old act.
Old act. Yes. CRPC.
CRPC.
Section.
Your lordship may come straight to 484, repeal and savings. Otherwise, it is in perimeteria to 531 of the new code.
Yes.
Your lordship will find in the old code, the proviso provided that every inquiry under chapter 18 of the old code, which is pending at the commencement of this code, shall be dealt with and disposed of in accordance with the provisions of this code. This proviso is absent in the new code.
Yes.
Otherwise, if your lordship comes back to subsection 2, notwithstanding such repeal, it is absolutely identical to the new code. So therefore, this is an indication of the fact that perhaps the proceeding initiated under the old code will continue under the old code. In my respectful submission, my lord, this is a matter which not only requires consideration, perhaps your lordship may like to consider this aspect that the matter needs consideration by a larger bench.
It's particular to inquiry under chapter 18 of the old code.
Old code.
Proviso. Why this is relevant?
Because that
it is clear.
Wherever
Proviso is being given that the inquiry under the old act, under chapter 18 will continue.
Will continue.
No, it shall be by the new, in accordance with the provision of the new act. I mean, this CRPC 73.
But your lordship will kindly appreciate the situation that an investigation, the ball is set rolling under the old code. And naturally, the other provisions relevant to it will also proceed under the old code.
See,
but as soon as
so far as the application filed under the new act, say for in BNSS, this is an application. That application will be considered. Will the merit, the offense will be considered in as per the old act. The application which will be filed after the coming into force will be considered on the basis of that act only. And naturally, by now there is no judgment as such dealing with 530. I mean, what is 528? adjourned date.
528, this one is there.
It's more or less like 438 only.
Patna wala 528. I think Patna is 528.
Okay, then.
This, my lord, some consideration perhaps is
We'll
required.
consider what's there. We'll give our view.
So
If
far-
there is a judgment of the coordinate bench, if I find that if I don't agree, I will place before the Chief Justice for coordinate bench. That's all, with the reason.
Yes.
There are one point just, if I may be allowed to.
Patna wala, yeah.
Is after coming into force of the DNS, if we file in the old provisions pending investigations, will it will it not amounting to revival of the repeal act? If that is be so, then my lord may have to recourse to section 7 of the General Clause Act. Then once there cannot be an automatic revival of the old act once it is repealed. And if that is be so,
No, it's not a question of revival. There's a saving clause. 531 is a saving and repeal and
Yes.
saving clause.
Yeah.
So 531 2A is under consideration.
So then I think AG was right, Miller, because then in that case, Maxwell treatise of interpretation of the statutes will come.
Will not
Where
go.
it says that all
Will not go that deeper. That will be determined by the larger bench.
I know, Miller, even that there was one judgment, if I recall, on this thing. This AIR 1960, Miller, SC, page 89.
AR 1960, page
Page
AR 1960 SCC,
SC, page 89.
AR 1960 Supreme Court, page
Page 89, Miller.
89. Find out.
Jetanan versus
Find out.
State of Delhi.
Get it? Huh.
I think that would be more better. Because what I thought of, Miller, after going through the conflicting judgments and all, then I find that it is nothing but more or less revival of the old act.
Thank you.
This is, one is Patna, one is Punjab and Haryana.
Which says that
New Act.
it will be
New Act.
new act. Okay. Then what about this section 4? They're saying that to interpret the section 4 has to be read along with this 531. That is BNS, new act, BNS. NSS, double S.
That is, 4-2 makes it even more interesting. Ultimately, on this issue, I think from some High Court, it will go to the Supreme Court very shortly. 4-2. All offences under any other law shall be investigated, inquired into, tried, and otherwise dealt with according to the same provisions, but subject to any enactment for the time being in force regulating the manner or place of investigating, inquiring into, trying, or otherwise dealing with such offences.
Interpreting Telegraph Act.
What does it mean?
That is what, if we read it together, 531 and 42, this is again indicative of the fact that the earlier code will continue. All offences under any other law shall be investigated, inquired into, tried, and otherwise dealt with according to the same provisions.
But subject to any enactment for the timing in the course regulating the manner or place of investigating into trying or dealt with such offences. Dealt with and otherwise inquired into, tried and otherwise dealt with according to the same provision. Same provisions means what?
Assuming there is a provision, hypothetically speaking, there is a provision in some other act which refers it to CRPC, then the CRPC will continue to hold the field.
Investigate, inquired into, tried and otherwise dealt with according to the same provisions. Yes. It's okay. If that is the meaning, it's okay. That will continue. What does it got to do with this 531? So far as the applications are concerned.
That is where the confusion comes. Now, once an investigation is initiated, resulting in a trial, leading up to either way, a decision either way. Now, an appeal or an application in connection therewith is filed.
This code is not of that view that this provisions, all provisions, CRPC, in any case after the enactment of new, the BNSS will not apply. I'm not, for a moment, I'm not on that. This is a provision where in other acts, suppose, as you said, CRP has to be applied for inquiry and trial, right? It will continue.
Yes.
May not be, proper.
Your Lordship is
sounds not proper in view of the new enactment.
Yes.
But then why not concern?
Yes. Your Lordship is confining it only to the application.
Yes. To the if until that time we are called to decide on it.
To that extent, Your Lordship is
today,
Your Lordship is confining it only to the application.
Applications.
I appreciate that.
Not even the appeal and other inquiry or trial. Applications only.
Then that Patna and Punjab and Haryana, they are saying.
What is this judgment?
This is my friend.
That was interpreting the Telegraph Act 1949.
Your Lordship, it is the interpretation of application by the Honorable Supreme Court.
Yes.
The word application has been interpreted.
Okay, 484, identical perimetry of 531.
But here the problem is this was already a pending application. This is not a new application. And ultimately Supreme Court refrained from giving a final, if your lordship sees the last few lines of paragraph 8, maybe last sentence one. But it is not necessary to express any final opinion on that point because a revision application of the kind before us is not by any reckoning such an interlocutory.
Where it is?
Last sentence of paragraph 8.
8.
Paragraph 8.
But it is not necessary to express any final opinion on that point because a revision opinion is before us not by any
And next paragraph, paragraph 9.
revision opinion made by was pending before this when the new court came in was in lieu of section. So yes.
Situation is slightly different. Your lordship will take a call. If your lordship
Thank you.
differs, so all right.
Let's go ahead and get the printed copy. Yes.
Your lordship hear us tomorrow.
Yes. You are not ready today?
I did not bring the citations. Actually,
Okay,
my
but
learned
here-
senior, which he was referring to section 4 and 531. There's an interpretation given of these sections and held to be under the new act.
Since I'm hearing
but,
Mr. Panging tomorrow, I'll
yes.
also hear you today. Are you
Obliged.
ready today? Or tomorrow? Tomorrow.
Otherwise, my lord, my submission will be there, my lord. The interpretation, my lord, has to be made on the basis of the golden rules of the interpretation. my lord.
Yes.
Both are very clear and unambiguous, my lord.
Yes.
Pending, my lord.
Yes.
So, my lord,
So according to you, it should be
new act, my lord.
new act.
And my lord, I will give those citations, my lord.
Yes.
Plain and simple words, my lord.
Yes.
Without having any ambiguity, my lord.
Yes.
The 2001 or SSC.
Yes.
534.
534.
26.
26.
It was my lord, reprinted in my lord, 2014, my lord. 6, my lord.
Yes.
SSC 335, my lord.
335.
Paragraph 2 and 239, 23.
2 to 23.
22 and 23.
Yes.
And another matter, the saving clause has been interpreted, my lord.
Yes.
In my lord, reported in 1996. For SSC 297.
297.
Paragraph 21.
20. Okay.
And my lord, case is my lord, judgment, my lord, that was about the High Court, my lord.
Yes.
Given detail, my lord. Yeah. The interpretation of this is everything, my lord. Paragraph number. Internet page 24, paragraph 45, my lord. The three issues were, my lord, issues were framed, my lord. Internet page 24, my lord.
Yes.
Paragraph 45, my lord.
Hmm.
Three issues were framed, my lord.
Yes. In the case reference by the
Second, issue number 2, my lord. Point number 2, my lord. Page, next page, my lord. Whether bail application filed by respondent successor
would be governed by the
7/2/24 would be governed by provisions of successor or successor. And it has been answered at paragraph 69 onwards.
69.
69 to 74 now.
Yes.
May I just read out the matter, saving interpretation of the saving clause matter?
Yes.
Paragraph 20 matter.
Which one?
Paragraph 20 on matter. 1994.
Yes.
The saving clause provision or clause may have been preserved what exists now. The exterior implementation by AFR Dominion, second edition in the manner authority with regards to saving clause has stated. The saving clause is a provision, the intention of which is to mirror the effect of the enactment to which it refers for as to preserve some existing legal rule or rights from its operation manner. What matter? By repealing of the old act matter, the new act came into existence. But under the old act matter,
yes,
by the law matter, some rights has been accrued matter, and to protect that rights matter, this saving clause is inserted matter. The moment that is over matter, the new act will take its own matter, and it will come to an end matter. Logical end. Okay.
First of all, your lordship, when an act is repealed, a new act comes, either it will have a retrospective effect or a prospective effect. No doubt, your lordship, when procedural law come into force, your lordship, and it is always presumed that when procedural law come into force, it will have a retrospective effect, unless contrary to the legislative intention can be observed, your lordship. Now, your lordship, firstly, your lordship, the saving clause does not destroy the earlier code, your lordship. It entirely. It says when pending, appeal, inquiry, application has to be governed by the old code as if the new Sanhita is not in force, your lordship. Now, your lordship, as your lordship has pointed out, only for the purpose of the application. Now, the second issue would be, your lordship. Now, today, item number 3, under BNSS 5, under 528, an application has been filed. That is the corresponding section of 482. They are challenging the cancellation of the bond. And bond has been cancelled under CRPC. Since they have invoked the BNSS, the provision of the BNSS to be governed, your lordship, while considering all these aspects, your lordship. And there is in the saving clause, it doesn't say if any action done by the court, then
The cancellation was before the coming into force.
No, Your Lordship, after Your Lordship. Oh, cancellation was before the coming into force.
Application is this 482.
Yes,
I
Your
mean,
Lordship.
What is this?
528.
520 is after the coming into force.
Yes, Your Lordship. Then Your Lordship,
We'll consider the pending the application or the inquiry on that day while considering the application.
meaning thereby Your Lordship, two court will follow.
Yes, it is what it says.
According to me, Your Lordship, the provision which
The offense is under section 380,
yes, Your Lordship.
right?
Yes, Your Lordship.
And your this application is 438.
Yes, Your Lordship.
438, I mean the 520, this, what is that?
528 is the
528 will be application will file before this court.
only limited for the purpose of application.
And the section, the 380 will be considered under the IPC.
CRPC. CRPC, Your Lordship.
CRPC will consider the application.
No, Your Lordship, I am not on the offense, Your Lordship. Your Lordship, I may not be able to apprise this court. Your Lordship, I am saying about the cancellation of bond and cancellation of bail, which has been granted by the Honorable High Court. And later on, Your Lordship, due to non-compliance of the summon, the bail bond was forfeited. And basing on that, NBW was issued under CRPC. Now, if they invoke 528,
Consider that on that day.
today is fixed, Your Lordship. Today is item number 3 only.
Will allow the application to file under this new act and will consider under what provision they have considered. That will consider.
Your Lordship, Your Lordship, unless or until it is deferred and referred, Your Lordship, the coordinate bench judgment will prevail, Your Lordship.
That I know.
Yes, Your
We're conscious of that. I'm not oblivious of that.
And Your Lordship, no doubt, this application is filed under 428 only, Your Lordship. 528 only, Your Lordship.
I've understood you are supporting the judgment of the Rajasthan and the coordinate bench.
Yes, Your Lordship.
That's all.
And,
I'll record your submission. You are supporting this. This is the correct.
And Your Lordship, this one more interpretation on Your Lordship. The learned AG has, Your Lordship, referred to the saving clause of the 484 of the earlier code, Your Lordship. There, this proviso give retrospective effect, Your Lordship. If investigation has been carried out and if it is pending during commencement inquiry, after a charge sheet is filed, that is the stage of commencement inquiry, Your Lordship. At this stage, if case is pending, then it will govern by the new court. And that provision give it a retrospective effect because at the time, in the present case, Your Lordship, when the
There's
offense
no provision as such in the new BNS.
that is what, Your Lordship, what I'm trying to make out, Your Lordship. The act has a retrospective effect. And if the offense is committed prior to or the FIR has been registered prior to the coming into force of the new code.
Your submission is that since the new act doesn't, I mean, the BNS doesn't have the retrospective effect.
Yes, Your Lordship. It has not been given retrospective effect.
It has not been given retrospective effect then.
So, Your Lordship, any offense or any FIR or any investigation or any inquiry appeal is pending, Your Lordship, that will be governed by the old code itself, Your Lordship.
Who is disputing that? The issue is under which provision or new or old act the application or the petition will be filed.
Under, Your Lordship, the old code, Your Lordship.
I beg to differ. I don't agree. That is your submission.
Yes, Your Lordship. Because, Your Lordship,
that is what the coordinate bench has decided. Right?
Yes, Your Lordship.
So
And
from there, that's why we're hearing you.
And Your Lordship, the coordinate bench has
Because I have a tentative disagreement.
yes, sir. And coordinate bench has reflected the, Your Lordship, saving clause of the BNS as well. Your
Will
Lordship.
also reflect.
Yes, the BNS, Your Lordship, that BNS also says as a repeal and saving clause, any remedy.
Because the coordinate, if I not had any disagreement with it, why I should why I should this matter is being heard now? I had a tentative disagreement by reading the perusal, by going through the judgment and the order. I'm hearing you.
Yes, sir. I'm just, Your Lordship, pointing out the difficulty what will cope up, Your Lordship, because it's a transition period, Your Lordship.
Take care of that as and when it is at the appropriate stage. We'll take care of that. We cannot visualize this could happen, that could happen. Will not. You may be correct. There may be difficulties, but we cannot At a time, we cannot visualize everything. That it could happen, it could not happen. What had happened, we'll consider that. If it is comes to an appropriate stage, we'll consider.
The only issue, as far your lordship has, is fallen from your lordship, so far as only filing of the application is concerned, then it's a very limited issue, your lordship. Only filing of the application. If that filing of the application.
What my learned friend is saying, I must, the law is very clear. So far as retrospectivity is concerned, it has to be expressly confirmed. What my learned friend has just submitted on that, I respectfully differ a little bit. That the cardinal principle of interpretation is, if retrospectivity is to be assigned to any provision, it has to be expressly given. Here, it is absent. Retrospectivity is absent. To that extent, your lordship is right. The new act will come into play, so far as applications are concerned. However, the problem arises because of the several conflicting judgments of several lines. Ultimately, we need clarity. So, whatever your lordship will take a call and let the law be conclusively decided.
I'm not saying as of now that my view may be correct or may not be correct. But
We
as of
ultimately
today,
need clarity on this.
Yes.
Because the litigants should not suffer because of.
I'll give my reasons. We'll hear them tomorrow.
My friend, I told him to make a compilation of all the judgments for your lordship's convenience, all the different high courts.
And ultimately, it has to be placed before the chief. Larger bench will decide.
Right.
Okay. So we'll continue tomorrow.
Okay.
We'll hear Mr. Pangin and Mr. If you have anything more other than what they learn a single judge, the coordinate bench heads.
No, it's okay. Tomorrow I will try to find out more
you-
authority on it, your lordship.
I'm not saying that I'm not accepting your argument. You may be correct. I'll determine.
Because your lordship,
Consider everything.
my only concern
But
is.
one thing you should remember, just you cannot visualize.
Yes, your lordship.
This could happen, that could happen. If you reinterpret, we'll interpret to the best of our knowledge on the attending facts and situation at this relevant time. Not the future, thing, unless it has got relevancy. You cannot visualize everything. No one can. Right?
Yes, your lordship.
Who else are appearing in all this matter? Item 1, 2, 3. Separate order, huh?
I'm for one.
And Mr. Item 1. Sorry, it will take time. You have to face the thing, situation. You have to bear with it for some time. So and so, let it counsel for the petitioner. In item 1, heard. No, you should heard Mr. So and so, huh? In item 1, and also heard the Advocate General. And Mr. T, assisted by T at Planet Edition PP. And Ditado. Since the identical method with regard to the identical issue which relates to bail application is listed on 08/08/2024. The comma. The issue as to whether the bail application or petitions would be filed under the new act. After the coming into force of BNSS on 01/07/2024, or in view of the saving clause provided under Section 531, bracket 2, bracket close, bracket is small a, bracket close of BNSS. Same would be continue to be filed under the CRPC 1973 within bracket, now repealed. List the matter on so and so. In tomorrow, on 8 so and so, along with bail application so and so. What is that bail application?
Yes, bail application, other applications are also, yes.
Bail application number you just.
Yes, AB, two AB, sir.
AB.
Yes.
You get the number and give.
Okay.
And item 2, Mr. Desai here, same order. Item 3, TY Bhutia, same order. Same order.
All right. then.
Malad, this is application of 439, Lordship.
Yes.
Yesterday, the learned PP wanted to bring on the record of the statement of the one of the
Yes.
witnesses, Lordship.
Now here also you will see the same issue. It is filed after implementation of the new code, your lordship, file under 439. This issue again coming this.
Same. When did you file this application?
Yes, Malad, it was, yes, it will be same, Malad.
My lord, but just thinking, my lord. Now, assuming your lordship differs more, the matter is sent to a larger man, that will take time.
Yes.
But this case is only merit. Ultimately, when you decided,
You will immediately place with the chief. Once we differ, once I differ, it has to be placed with the chief. This is a call of the chief.
there may take some time. What I will submit is, this bail application, all bail application, because I am also proposing to file something tomorrow.
That is the difficulty.
People are inside there. So, what I am going to submit in this application, bail applications, I don't think there is a bar for taking up. This issue is always there. It will be ultimately settled. The bail application may be referred to be taken up.
That will be taken up also tomorrow. The issue will, let us ponder on it. I'll also think about it. Because
We don't know when the Honorable Chief Justice will fix a larger.
hopefully it should
a
be.
month. We don't know. In that case, I don't
See,
think
we have
bail
seen
application-
also, in other matter also, was fortunately privileged to be with the chief. Last week only disposed of. There was a juvenile,
Maintainability of the anticipatory bail in juvenile case of juvenile.
have you seen it?
Yes, I've gone through it, your lordship.
We have agreed the Allahabad and Punjab and High Court that it should be
Yes.
maintainable.
Now it's maintainable.
Because ordinate bench, other first, they said it's not maintainable. And Justice Kalita has deferred and placed it. So it took another maybe 2 months.
That's right, that's right. Why don't we
Then ultimately we have
take
sent,
note of this issue also
because
tomorrow?
the
Because as of
division,
now, rightly or wrongly, the coordinate benches will come to a finding. So maybe the applications can go on in that manner, and thereafter when they are.
but at least I cannot, once I defer. Some other,
way.
unless there is, some other bench can take it up.
Otherwise, on merits, might not be.
No, once we decide the maintainability, very difficult to go on to the merit. So we'll think about it.
Yes, but.
Because just because of that pendency,
Further-
the litigants or
regarding step also.
the applicant should not also suffer.
Yes.
We'll decide tomorrow if this is the same thing.
Yes, application, of course, Malad, I might.
They will do something.
Yes.
We'll take up, I'll take a call tomorrow.
Yes.
Whatever, if this court defer also, I mean, at a disagreement also, we'll do something.
Yes.
We'll just not let the.
Some
litigants
middle-
suffer.
This issue was dealt in Kerala High Court case, your lordship.
Yes.
It is held when it is not amounting to non-maintainability because the power is traceable from the provision of the statute, your lordship. Either
Yes,
BNS.
it's there.
Yes,
You
it's
have
there.
the
your
judgment.
lordship.
We'll place tomorrow.
You place it tomorrow. We'll take it up.
Yes, ma'am.
So let us, please bear with us.
I also want differ.
I should not have ventured into this, such a big ocean.
Yes, obliged.
Your Lordship, CD may be retained, Your Lordship, in order.
Yes. And Mr. So-and-so. Same order in view of this so-and-so, please this matter. Same. Same.
Based on coordination.
We'll take up tomorrow. We'll not take up other cases tomorrow.
LCR not receiving.
That in this case,
LCR
LCR
is not
is
there.
required.
LCR has been called for but not received in this case.
Okay.
So-
And Mr. DK Dere. That will guide, and then we'll not fix it tomorrow.
Yes, then it
DK
can be
Dere,
on
learn
19th.
consent for the applicant. Also had Mr. T at the London additional PP for state office note. No, LCR was called for. No, trial court record was called for.
Trial court.
However, same is yet to be received. Registry to send reminder.
Yes, Your Lordship.
Your registry.
No, you register, Your Lordship.
Registry to send reminder. List after 2 weeks.
Can it be on 19th?
2 weeks.
19th.
On one,
19.
and on 19, 190820.
Deeply obliged.
Same issue will come up, Manoj.
Same.
Well, my case is a bit different because trial has already commenced in this case.
Okay.
And then in incarceration for long, Manoj.
Whether it's 439 or other,
439.
same we'll consider tomorrow.
Yes.
But then CD is there.
Yes, LCR also, but it was
LCR is there.
yet to receive, not to receive.
Not received. 19.
Both the
This will guide.
Yes.
Heard Mr. Tititar, then counsel for the applicant. Office note reflects that. Office note that the 060824 reflects that. Scanned copy of the trial court record is yet to be, has not been received. Registry to send reminder. List the matter on 19.
Manoj, very unusual request I am making, Manoj.
Yeah.
Just, I am not, and my health is not getting well, Manoj.
It's due to old age or something.
No,
something else.
this is viral something.
Or
else.
are you started having something which
No,
is
no.
foreign to your body?
28, Manoj. I requested
28.
28.
Item
No,
28.
item 28, Manoj.
Okay.
Kindly accommodate us on 12, Manoj. I apologize for.
That matter.
This something.
Supreme Court and back.
Yes, madam.
Yes.
This matter, my lord, something has happened to it.
So I thought I'll dispose of this matter somehow today.
12? Hello, my lord
I
is
was
here only.
thinking, since you are not making a mention in the morning.
I would
Okay,
have, I would have
we-
vehemently objected, but my learned friend is
Because
not
of-
well, he says.
Mr. Titi Taralan, counsel for the petition, appeal applicant,
18K.
make a mention that matter may be
17.
listed on 12.
12,
12, is it possible?
Yes, yes, my lord. I'm
Something, my lord,
waiting for it.
sometimes my
8/20/24.
12, huh?
He's not
Interim is
keeping,
there.
his health suddenly, he's not feeling well suddenly, well, in the court. The Mr. Deepangilan counsel has no, applicant has no, the respondent has no
Respondent number 1.
objection. Respondent number 1 raises no objection.
Yeah.
Accordingly, list this matter on 12 so and so.
Item 18 also, my lord, that 439 only.
19.
19. Much obliged.
17.
Item number 18, 18 said. 18, 19.
Same order, Titi Tara.
17, 18.
17. 19, huh? Fixing 19.
On 19.
On 19, with same order as 17. Yes.
Yeah, my lord.
Yes.
This is an application for condonation of delay, my lord,
Of what?
of 3,125 days, my lord,
For filing what?
for appeal, my lord.
Appeal.
Yes, my lord. My lord, I have on two counts, my lord. I will try to impress this honorable court with sufficient cause, and another ground is for suppression of matter of facts by the defendants, by the respondents, my lord. Now, my lord.
Have you any objection?
Yes, I have an objection.
You have filed an objection?
Yes, I have filed.
Okay. Yes.
May I, my lord? Yes, ma'am. My lord, we both are the sons, my lord. And we both are children of Suchu Cree / Suchu Muley. my lord. Now, my lord, this Suchu.
Your brother?
Yes, stepbrothers.
Real
Stepbrothers. Stepbrothers. First, my
Real
lord,
or step?
stepbrothers.
Step.
What happened? My mother was married to their father, my lord. After the death of their father, my lord, my mother married to my father, out of which we are born, my lord. From first marriage, my lord, they are born. From second marriage, we are born, my lord. We are both from same mother, my lord. So we both are the children of our mother, my lord, which is known as Suchu Cree or Suchu Muley.
Let us not go into that.
Yes.
Why delay of 3,000? What is this? Delay of?
3,125 days, my lord.
Yes. What is the what was?
Now,
What
my
was
lord.
the order?
Yes, my
Title
lord.
suit.
Yes, my lord.
When is the judgment and order?
Page
2015.
20. Yes, my lord.
Yes, what is the ground? Let us see.
My lord,
It should
suppression
tell
of
us-
material facts, my lord.
Hmm.
We were not made as a party, my lord. This is a legal hair certificate they have filed, my lord. Now they declared in para 3, my lord, page 21, my lord.
Page 21.
Yes, my lord. Para 3, my lord.
Hmm.
The case of the plaintiff is that he is the son of late Goke Muley and Srimati Suchu Muley. He has one elder brother, namely Sri so-and-so, who is the respondent number in the present title suit. To substantiate his claim, the applicant have also annexed the birth certificate and ST certificate issued by the competent authority, wherein like so-and-so has been indicated as father and mother of the plaintiff.
Okay.
This is
So
the order.
your name is your?
My name is not your honor. My
No,
lord, may please.
your by this applicant, your Bitukri.
I am the Bitukri, yes, my lord.
Huh?
Yes, Bitukri.
And Sondikri, who is Sondikri?
Sondikri, respondent number 2, my lord. Applicant number 2, my lord.
And Srimati Indrani.
My sister. We are 3, my lord, from second marriage.
Plaintiff is Raju Muley.
Rajan Muley?
Rajan Muley.
Yes, my lord.
He's your
stepbrother.
stepbrother.
Yes, my lord.
So by this, what do you want to do?
My lord, may please come to page 16.
Only one elder brother.
Yes, my lord. My lord, may please come to page 16. That would clarify. Page 16.
Yes.
This is the application, my lord. Filed by the my lord, respondent number 1. My lord. Page 16, my lord.
Yes.
This is the title suit, my lord. Cause title may be seen in the matter of suit for declaration of Mr. Raju Muley as legal heir of Srimati Suchu Muley, my lord. This legal heir certification, this application, this title suit has been filed for seeking legal heir certificate in respect of Suchu Muley, who is the mother of both petitioner and the respondents.
So you are not party to the.
They have declared, my lord, that yes, my lord, they have declared that they are
When
the
did you
only.
come to know?
My lord,
This judgment. What is the judgment?
my lord, page 17 may please come, my lord, page 17, my lord. This what I am saying, my lord, there is a separation of material facts, my lord. The petitioner begs to para 5, my lord, page 17. The petitioner begs to submit that his mother died on so and so, leaving the petitioner and the respondent as the legal heir of the deceased one. Further, it is to submit that the said plot of land was inherited by the petitioner's mother from their father.
Yeah.
Now, my lord, they made a declaration that they are only the children of let Suchu Muley / Suchu Cree.
Okay.
Yes.
When did you come to know the judgment?
Judgment in the year 2015.
Under appeal.
2015, my lord. Then I submitted an appeal, my lord, before the deputy commissioner, my lord. May please come to page 40, my lord.
48.
Yes. On 24/9/2015, I filed an appeal, my lord. Report to Deputy Commissioner in the wrong forum, my lord. Then, my lord, what
This
happened?
was the judgment is
By the district judge, my lord.
then you file an appeal.
Yes, my lord, before the Deputy Commissioner. On the
Against
wrong forum, my lord.
against the judgment of the
Yes, my lord.
district judge.
Yes, my lord. In the wrong forum, my lord, obviously. my lord. Now, what happened? Notice were issued, my lord. Page 42, my lord. In the wrong forum, my lord. Yes.
Yes.
Page 42, notice were issued, my lord. Now, against this notice, my lord, we have submitted a representation on page 43, my lord, on 28 April 2016, my lord, for deferring the case, my lord, because I have been newly appointed as a, may I read, my lord? Second paragraph, that sir, currently I am in Itanagar anticipating start of training very soon after my selection into Arunachal Pradesh Civil Service 2016. The process of joining service is underway with start of medical examination fixed on first week of May, my lord. So on 2016, my lord, I create an application for delaying the matter, for adjournment of the matter. Now on 2017, my lord, the Deputy Commissioner has passed the order, my lord. Page 44, my lord. The relevant would be page 45. The order, my lord. From the finding and observation and after going through the material placed on record, I am of the view that disputed land as reflected above belongs to Srimaji or Sri Rajan Muli on the strength of legal heir declaration. Then, my lord, we were unaware of this order, my lord, of the Deputy Commissioner. My lord. So, because order was never, my lord, intimated to us, my lord. I came to know about this order in the month of February 2021, my lord. Then, my lord, I filed an application before the district judge, my lord. Page 23, my lord, is my application, my lord. Before the district judge, I have filed an interlocutory application, my lord, for revocation of the legal heir certificate. My lord. Now, since, my lord, I have filed under the wrong provision of law, my lord, I have withdrawn the application, my lord. Last page, my lord, page 51, my lord.
Application of what? This title suit?
Yes, my lord, for revocation of legal heir certificate. Yes,
223. Huh?
my lord.
Page 23.
Yes, my lord, page 23, my lord. My lord, may I please come to the last order. my lord?
Yes, then
Page 30, my lord. Yes, my lord.
51.
Yes, 51, my lord. Then we withdraw, my lord, because we have filed under the wrong provision of law, my lord. So on 31/3/2022, the application was withdrawn, my lord. Now then, my lord, what happened? This after 31/3/2022, my lord, the file was with the learned counsel, my lord, until September, my lord, 2022, my lord. Then on October 2022, they have changed the counsel, my lord. The applicant's hearing has changed the counsel, my lord. And from October till filing, we have filed this application in the month of on 9/11/2022. So from October till filing, my lord, for preparation of this drafting, my lord, we took some time. So what we are saying, my lord, we have tried to impress this court that yes, there is some our sufficient cause, my lord, for delay, my lord. And my lord,
When
there
you
is
have made your statement.
yes, my lord.
Your statement.
Yes, my lord. My lord, paragraph 4, my lord. 7, my lord. Page 7. May I read, my lord? Page 7. Paragraph 4, my lord. In the month of September, the applicants came to know that the respondent was trying to grab their land by changing the ownership on the strength of impugned judgment order so and so. Learning the fact the applicants on so and so have submitted a complaint before the Deputy Commissioner Lohit District, and because not to process transfer of ownership of immovable properties recorded in the name of so and so. It is admitted fact that since the applicants are laymen to law and its procedure, the applicants inadvertently approached wrong forum before the Deputy Commissioner Lohit District. It is stated that upon filing of the complaint, the applicants got engaged in their usual work. The applicant number 1 went to Delhi for preparation of civil service, and after selection.
What is that?
Yes, Your Honor, for deciding the limitations part, the merit of the case cannot be taken
That's
into
what I'm
account.
saying. This reason which he has narrated,
He have to state everything what he had done from
Well, cons-
since September
I'm-
2000.
I'm satisfied, prima facie. We'll conduct. We'll conduct the delay.
No, Your Honor, because he have to specify everything.
It's okay.
There's a judgment in this regard with regard to the limitations, condonation of limitations. I'm referring to this judgment. It's a latest judgment.
Page.
Page, para 7 onwards.
Not onwards, just give the relevant.
It has decided everything.
Not
what
adopt
to
the
decide.
justice-oriented approach in dealing
The law of
with
limitation is founded by
the
policy on public policy. It is,
Rather follow a pragmatic line to advance the substantial justice.
yes,
Para 13.
para 13, para 14 also, it is also important to point out that though on one hand, the section 5 is to be constituted liberty, but on the other hand, section 3 of the limitation being a substantive law of mandatory nature has to be interpreted in a strict sense. In Bakmal alias Rambak's this, it has been observed that different provisions of limitation that may require different constructions. As for example, the court exercised its power in a grave case liberally in condoning the delay in filing the appeal under section 5.
This is under section 3.
He had filed under section 5.
Then
section 5 says it is a
it
mandatory.
has to be considered liberally.
Yes.
Yes.
And he have to give, it's therefore follows that though liberal interpretation has to be given in considered section 5, but not in applying section 3 of the limit, which has to be considered strictly. It is para 15. It is in the light of the public policy upon which law of limitation is based. The object behind the law of limitation and the statutory mandatory, the directory nature of section 3 and section 5 of the limitation are there, that we have to examine the strict balance between section 3 and section 5 of the limitation in a matter of condonation of the delay. Then I will come to para 17, Your Honor.
Considering subsequent cause in direction without the section for that and the expiry period is due to the simple that will pay a detail in this when you that procedural section. Yes, there are 26 is the.
Yes.
This was a case where the petition, the applicant has sought for a similar
Yeah.
condemnation of delay.
Condemnation of delay.
Is the other, in other case, some similar relief was given.
Yes.
So that cannot be a ground.
Yes.
But the substantial justice and section 5 has to be liberally construed
Liberally.
to give substantial justice.
Yes.
Will condone.
No, Your Honor, because here he had not even explained the sufficient cost also.
Heard, Mr. Anything else? We'll refer this. Huh?
But I
See,
pray for.
Though it says at the time of condoning the delay, consideration for condonation of delay, marriage should not go into.
Yes.
But having seen your conduct also, you have obtained the what is it called?
Order, my lord.
No.
Judgment and order.
Judgment and order on the basis of the documents.
Yes, ma'am.
By suppressing the material facts, you have obtained the what?
My lord, there is a judgment
No,
on
no.
suppression of material facts.
There is no any
Delay
separation
can
of
be got on.
material fact, Your Honor. Here the fact is that the land, because this is a legal hair certificate, it is basically deal with the land. The land which for which the
No,
certificate.
you have only said that one person is only your elder brother.
Yes.
What about them?
No, they are not my brother. They are step brothers. The land, the fathers are different. It's not that we have the same father. Our father is different. He belongs to some other father. I belong to some other father. And when
You have the same mother.
same mother.
And legal hair certificate has been, my lord, issued in respect of mother, not the father.
No, this is respect in respect of for the two sons. But father I had Gingo Muley. I had not mentioned his father name. I've specifically mentioned.
Para 6 and 7.
No, what is that? What certificate? Legal
Legal hair.
Legal hair certificate.
Legal hair in respect of mother only.
Mother
Yes,
only.
mother.
Then
Legal
then
hair.
he's also entitled.
Yes, ma'am.
But you cannot disown him. If
But-
had it been your own father,
Yes.
legal heir, then matter would have been different.
But here,
You may claim so. But he said legal heir on the basis of which you have obtained the decree or the judgment is in pertains to the mother.
Yes.
that is pertain to the matter. Even I'm not saying it's
Then-
pertain to
then-
the.
Then why you can, that is the basis of decree
Yes.
or the order.
Now I came to his
Yes,
application.
what is the judgment?
2002,
Hmm?
9 SCC, my lord. It is there, my lord.
Yes, right.
Only 2 paragraphs I will read, my lord.
Put it here. Here.
2002, my lord, 9 SCC, my lord. On separation of material facts. Delay can be condoned. Para 6 and 7, my lord. 2002 9 SCC, page 764. my lord. 764.
Yes.
Para 6 and 7. my lord. The tribunal would appear to have lost sight of the cardinal principle which enshrined in section 17 of the Limitation Act that fraud nullifies everything. my lord. If the tribunal was satisfied as it ought to have been upon these facts that there might have been some fraud, there was very reason for it to condone the delay and to hear the appeal. my lord. The judgment in so has no application to the facts as this one. The appeal is allowed, the order under appeal is set aside, the application for condonation of delay is allowed. my lord. Here what happened, my lord?
To apply this,
Para
how
4,
the
para 4 would be relevant, my lord. The facts, my lord. Facts, my lord. Para 4, my lord. The order of the commission was passed on. sir. And 5, my lord.
That's all.
And 5, my lord. The appellant thereupon filed appeal before the so and so, sir. Tribunal thereupon under challenge, my lord, was passed. It sought condonation of the in filing the appeal, setting out in the some detail of the reason for which the appeal had been filed after period of limitation. The tribunal declined to condone the delay, taking the So here, my lord, para 6 would be important. The cardinal principle, my lord. Section 17 says, my lord, limitation of 1 year, my lord. Here the cardinal principle has been taken, my lord, the fraud, my lord. Since there has been suppression of material facts, fraud has been committed on the court, my lord. So, my lord, the delay was condoned. Even our High Court has condoned the delay in this matter.
Don't give too much judgment here. Let us not multiply.
My lord, facts are paras 5 and 6, my lord. Facts, my lord, which starts from page 5, my lord, or para 5, my lord. Page 5, para 5, my lord. Here too, cardinal principle has been taken.
Okay.
Here, Your Honor, let me submit that what was the applications filed before the court for obtaining legal hair certificates. So may I read that he had annexed my petition in page 16, wherein I had declared that that the land for which I went for the transfer of the ownership, which land belonged to my father. But at that time, when Teju Times comes into being, then there was an special offers for that the land should be allotted to the lady, because that land originally belonged to us, to my father. Without acquisition process, there's when Teju Town was declared, they says, okay, fine, the land which you are holding, let that be allotted as per allotment. Accordingly, allotment was made in the name of my mother. After that, she married with his father.
Okay.
So when we were small kids, she left us.
So we decided in trial.
Still when did your mother die?
In 1994, yeah.
Let her soul rest in peace.
Yes, ma'am.
Because here in that petition,
You
we
share
had
the property equally.
Yes, ma'am. 8,000 square meter they have taken.
because in that petitions we had everything had been declared here. So petition he had annexed. But my prayer and my that's a citation which I refer to, that's maybe taken in.
Heard Mr.
Because
B. Pitcher, learned counsel for the petition. Applicant also heard Mr. D.K. Devi, learned counsel for the opposite party respondent, opposite
1
party.
and 2.
1 and 2.
Only one.
1 and 2.
1 and 2.
Anita Muinde.
Has been replaced. Initially, Momen Muli was there. He expired, so Anita Muli was replaced. Being the legal.
Opposite party oblique respondent number 2, 1 and 2. By next para, filing this application under section 5 of the Limitation Act, 1963. The applicants have prayed for a condemnation of delay of 3,125 days in filing the connected. What is the regular first appeal?
Yes, ma'am.
Regular first appeal
Yes, ma'am.
against the judgment and order dated 20/01/2014 passed in title suit number 19 in bracket L bracket close 2013 by the district judge Teju, Lohit district Teju, Arunachal Pradesh. The applicant has the grounds, the applicant has set out the grounds at para 4, 5, 6, and 7, right?
Yes, my lord. And 8, my lord.
6, 7, 4, 5, 6, 7, and 8, which are reproduced here in below. Huh? Next. Next, Mr. D. Pitcher, learned counsel for the applicants, while referring to the grounds taken in the above referred paragraphs, above referred paragraphs in the application, and also to the other documents annexed with the application, submits that the judgment and decree dated 20/01/2024 has been obtained by the opposite parties public respondents by suppressing the material facts and also by playing fraud with the court in as much as the basis of the imputed judgment and order and decree dated 20/01/2024 is based on the legal aid certificate.
Yes, my lord.
Pertains to the mother of late mother of were the applicants and
Yes.
the respondents.
Yes.
That apart, he contends that the applicants, after coming to know the judgment and decree that it 2014 had wrongly pursued the matter before the wrong forum,
Yes.
including the deputy commissioner and the district judge,
Yes.
and the wrong provisions, which ultimately was withdrawn.
No, deputy
and-
commissioner not withdrawn.
Huh?
Deputy commissioner disposed of.
No, including the deputy commissioner, learned district judge, which ultimately withdrawn. After that, he has filed an.
No, deputy commissioner, which he filed before the deputy, he has filed a memorandum for, may I read that particular?
It's okay.
It will make clear. Now, he had prayed for
Not
that.
clear. Whatever is passed, he has filed an application before he was pursuing before deputy commissioner.
Yes.
Some orders has been passed,
Yes,
right?
yes.
Against that, he has filed an application before the.
No,
district.
not against that particular order. Not against the order passed by the deputy
It's
commissioner.
okay. Deputy commissioner and the learned district judge, which the proceedings before the proceedings which before the learned district judge was ultimately withdrawn.
Yes.
That will satisfy your submission.
Yes, ma'am.
But
I'm not pointing on that. He was pursuing before the deputy commissioner.
Yes,
Then before the learned district judge, the proceeding which he has ultimately withdrawn.
Yes.
he had
All right.
withdrawn.
Mr. Therefore, he submits that he has, there is no deliberate on the part of the applicants in preferring the connected regular first appeal against the judgment and order 20-01-2024. And as such, they may be conducted. And such, the delay of 3,125
days.
days in preferring the present appeal may be conducted. He has relied on the judgment on the Mr. B. Pitcher, next para, the counsel for the petitioner has relied on the judgment of Honorable Supreme Court in the case of Joginder,
Commissioner of Customs.
Commissioner of Customs versus Candid Enterprises reported in 2002, bracket close 9 ACC 764, wherein the Honorable Supreme Court has held that the principle of the cardinal principle of enshrined in section 17 of the Limitation Act that fraud nullifies everything. And if it is satisfied that there might be some fraud, comma, there is every reason for condoning the delay and to hear the appeal. Mr. In the said case, the Honorable Supreme Court, after considering on its merit, has allowed the application for condemnation of delay. And directed the tribunal to hear the appeal on merits. He has also relied the judgment and order of this court in past dated 23/01/2019, passed in CRP 478 of 2015. To show that the one in this court has held, which is reproduced herein below. Paragraph 7,
Yes.
7, 8,
And 9.
and 9. You got this. Next paragraph. Mr. D.K. Learned counsel for the opposite parties, public respondents, vehemently object the submission of Mr. B. Pitcher, learned counsel for the petitioner. While vehemently objecting the submission of so and so. submits that there is no ground for condemnation of delay. No grounds is met out for condoning the delay of hopelessly delay of 3,125 days in filing the connected appeal. List of. There is no proper explanation, much less each day's explanation in the application.
Nor any supporting documents have been filed along with the supporting documents that they were taking coaching, so they were doing something.
He submits that no supported documents has been filed along with the application so as to show that there was no inordinate delay in filing the connected appeal after huge delay of his delay of 3,125 days. List of. But DK then counsel further submits that
Section 17 is not applicable in this case because they have discovered the fraud in the year 2015.
Further submits that the merits of the case cannot be considered at the time of consideration for condonation of delay. List of. Then
because if their submission is right that they had revealed the fraud in September 2015, then also Section 17 will not come into their relief. It says that the period of limitation shall not begin to run until plaintiff or applicant had discovered. So they had discovered in 2015, September 2015.
Delay of the Section 17 of Limitation
Right.
Shall not apply in the present case as there is no question of fraud during the proceedings before the learned district judge. List of. The list of, that's all. And
even if their claim is supposed to be believed to be true, then also the period will run from the date when they had learned about it for the first time. That is in September 2015.
Even if
because they say that there is a fraud had been played. So they claim that they learned it in September 2015. So period will learn from September 2015, not from the date of judgment. Because the proviso to Section 17, it says the period of limitation shall not begin to run until plaintiff or application has discovered the fraud. So according to them, they had discovered the fraud in September 2015. So after September 2015, the
it's okay, it will cover, doesn't apply.
Yes, sir.
Section 2 has no application in this case. This stuff. As the proviso clearly provides what
the period of limitation
shall
not begin to run until plaintiff application has
shall
discovered
not begin to run. Just give me. Limitation Act, Section 17. Just give me. Is the period of limitation shall not begin to run until plaintiff or applicant has discovered the fraud or the mistake or could, with reasonable diligence, have discovered it, or in the case of concealed documents, until the plaintiff or the applicant first had the means of producing the consent documents or compelling its production. Therefore, he submits that the present application deserve to be dismissed. There is no ground or no ground, much less the sufficient cause has been shown by the applicants for condoning delay, huge delay of 300 so and so days, filing the connected. Mr. So and so, counsel from DK Devalan has relied on judgment. The Honorable Supreme Court in the case of Pathapati Subba Reddy, within bracket died by LRS, Landers Basis, Special Deputy Collector within bracket LA, reported in 2024, SCC Online, SC 513. I have considered the submissions of the learned counsel for the consider the submissions advised by the learned counsel for the parties. Next slide. It is settled position of, it is settled law that courts should not adopt an injustice-oriented approach in dealing with the applications for condemnation of delay in filing appeals, and rather follow a pragmatic line to advance substantial justice. Generally, the courts have adopted a very liberal approach in considering the sufficient cause used in Section 5 of the Limitation Act in order to condemn the delay, to enable the courts to do substantial justice and to apply in a meaningful manner which subserve the ends of the justice. It is also settled that the ordinarily a litigant does not stand to benefit by lodging an appeal late, it is not necessary to explain every day's delay in filing the appeal. And since sometimes refusal to condone delay may result in throwing out a meritorious matter, it is necessary in the interest of justice that the cause of substantial justice should be allowed to prevail upon technical consideration, and if the delay is not deliberate, it ought to be condoned. Notwithstanding the above, however, liberal approach is adopted in condoning delay. Existence of sufficient cause for not filing the appeal in time is a condition precedent for exercising the discretionary power to condone the delay. It is also equally held by Honorable Supreme Court that the phrases within inverted comma, like liberal approach, comma, justice-oriented approach and cause for the advancement of substantive justice cannot be employed to defeat the law of limitation so as to allow still matters or as a matter of fact, dead matters to be revived and reopened by taking aid of Section 5 of the Limitation Act. Mr. Next one. On consideration of the materials as well as the submissions in the present application, comma, it transpires that the petitioner, the applicants, on having coming to know the judgment and order dated 2014.
Yes, Master.
Passed by the learned district judge, comma, Teju, has approached, has and filed an appeal before the Deputy Commissioner Teju. The Deputy Commissioner has disposed of the appeal by
February 2017.
on 17 on
23 February.
23
Yes,
23
February
23 02 2017 holding that what
Orders from the findings and observation that are going through the material placed on record. I am of the view that dispute land as reflected above belong to Sri Rajan Muli on the strength of the
holding that the disputed land belongs to the applicant.
No, respondent here.
No, respondents, namely
Rajan Muli.
Rajan Muli. Second is not there.
No, second is done.
Rajan Muli. Basing on the judgment and decree order passed by the London District Judge.
Yes.
Dated 20/01/2024. 14. 14. Thereafter, you filed an application.
Yes, Master, before the district judge. Master.
Thereafter, the applicants have filed an application, or what is that appeal?
Not
IA.
Filed an application being number
03
IA being IA number 03
under bracket L /
within bracket
2021.
of what
2021.
2021.
number 03 20 21. What was the application?
For revoking Master, the legal hair certificate. Master.
Huh?
For revoking the legal hair certificate issued to the respondent. Master.
Basically for revocation of the legal heir certificate obtained by the respondents.
Yes.
In respect of their mothers, their mother,
Yes, ma'am.
which according to the applicant was the basis for the impute judgment and all, basis for the judgment and decree passed by the learned district judge. Thereafter, the introductory application was withdrawn with a liberty to approach or file application before the
With a liberty to
appropriate
file
forum
afresh.
or afresh.
Yes.
Thereafter, the petitioner has filed the appeal, present appeal, present revision, the regular first appeal against the judgment and order that is so and so, so and so. List of, in the whole process, it took the petitioner a long delay of, a long period of 3,125 days in filing the connected appeal. List of. Next paragraph. Having considered having considered that privacy, and having considered having considered the submission of learned counsel for the petitioner, applicants, of having raised the issue of fraud while obtaining the legal aid certificate in respect of their mother, and considering that the applicants have pursued the matter in a wrong forum, wrong forum with bona fide, wrong forum bona fide, which consumed a considerable long period of 3,125 days, this court is of the view that the applicants could able to show a sufficient cause which prevented them to file the connected appeal within the period of limitation. Thus, I'm of the view that the petition, the present application deserve to be allowed by condoning the delay in filing the connected appeal. In the case of next paragraph, Patapati Subba Reddy, within brackets Supra, the Honorable Supreme Court, after consideration of all the earlier cases, earlier judgment, has held and observed, which is as follows. Para 26 of this case, which is quoted here in the next. Next one. In view of the attending facts of this present case, and also in the light of our legal position as enunciated by the Honorable Supreme Court of India, Honorable Supreme Court, I'm of the view that the applicants have made out have shown a sufficient cause which prevented them to file the connected appeal within a period of limitation. Within a period of limitation, accordingly, the delay of 3,125 days in filing the connected appeal is condemned. In the result, the application, the IA still is allowed and disposed of. That's all. We'll fight it out in the on the merit.
Yes.
But
Much obliged.
appeal may be dismissed. You never know.
Yes.
In view of the order passed, in the appeal, in view of the order passed in so and so, let the FAO be listed. This is
RFA.
RFA.
okay. RFA. In view of the order passed in so and so today, in view of the order passed today in so and so, in the IA so and so, let the regular first appeal be listed after 3 weeks.
Let him direct for taking steps, because only condemnation application was served to me. Because only after this allowing only RFA, he will have to take
They are appearing, my lord.
steps.
No,
No, I
but
mean,
yeah, what's
but you have to give me all the documents.
I will furnish extra copies.
The learned counsel for the appellant, Mr. B. Pitcher, shall furnish the memo of appeal.
Yes.
Including
Documents.
documents which he has relied, including the documents annexed thereto. But Mr. B shall furnish the requisite copy of the appeal petition along with the documents.
Much obliged.
We'll continue it to.
May I please, Your Lordship?
Yes.
Your Lordship, here in this case, Your Lordship, service report still awaited. Therefore, Your Lordship, I may be allowed to take fresh step.
Fresh step.
Yes, Your Lordship. It's been long time.
Okay. Office note dated 10/01/2024 reflects that etiquette in respond number 2. Still not yet returned back. Mr. So-and-so.
He may enjoy your lordship.
Petitioner to take precise steps for service of notice of respondent 2 within 3 days.
Yes, Your Lordship.
List after 4 weeks.
Much obliged.
And this record is present. Mr. G. So-and-so. Learn addition people.
Your service report is still awaited for respondent number 2.
Await service reports. In respect of respondent number 2. List after 4 weeks.
Yes,
Three
sir.
weeks.
Yes, sir.
3 weeks.
And we like to take a fresh step through PP.
You want to take?
Yes.
It's okay. Criminal petition.
Okay.
And you want to take precise step.
Yes, Your Honor, through PP.
This is what? Criminal
This-
petition.
Yes, Your Honor. Proceed.
You take various steps in that case.
Yes, sir.
No, it's step. Wait for some. Then next date we'll see. This chapter.
Interim maybe.
3 weeks. Interim order plus relation continue.
Your Lordship,
Yes.
Madam, maybe pass over timing. This is a TA case, so I may call.
Yeah, please, madam. I'm on behalf of respondent number 2 here. And the LCR was called from the executive magistrate.
Yes.
It has not yet received. However, the LCR is received from the learned court of district and session.
This is from the executive magistrate.
Yes, Actually, the order of the executive magistrate was challenged by way of revision before the district court of sessions court below. And the session court has upheld the order. The same has been challenged here. They have filed an application under 482 to set aside and quash.
So this 15.6 says not judicial. Okay. Office
From
note dated 06/08/2024 reflects the records in respect of records pertains to the case the Heritage versus Bamang Takha. From the executive magistrate internal capital complex yet to be received. Raised to send reminders. List after 4.
my lord.
I think you got 25. Office note dated 06/08 reflects that ID card in respect respond to was yet to be received back. List after 3 weeks. Mr. P. G. Tadolan is present.
My lord, the conducting counsel is from the Jammu and Kashmir. He is engaged in High Court of Jammu and Kashmir today. He has to appear through BC. I'm here only assisting this matter.
Where is?
He is from Jammu and Kashmir. And I have informed the
the
private respondent has filed already the affidavit on the
okay.
Yes.
What do you want?
Matter may adjourn and fix on 19th of this month.
On the prayer of learned counsel for the petitioner, Mr.
Tempahi.
So and so learned counsel for the previous this matter on
19th August.
08. Mr. G. Tado so and so is present.
In the meantime, my lord, the interim
This
order
item
36.
okay. Interim order first we are still continue.
Much obliged.
May I please, your lordship, we need some more time to file our affidavit.
What is the matter?
This is the cancellation of LPC prayed by the petitioner.
Lordship, I have called a petition.
And Mr. So and so learned counsel for the petition and Mr. MS Expera P. Sangita.
Yes, sir.
Learned counsel for the learned state counsel.
For the respondent number 1.
For respondent.
1.
Number 1. Respondent and the 3 weeks time.
Lordship, interim may be continued.
Interim order was only continue.
Obliged.
Much.
Yes. It's Miss Jayadodi.
She's not seen today.
What is the matter? What is the sentence? 30441.
Yes, sorry, Your Worship, I do not have the brief because PP is also absent here in this case. LH Hagya Lakshmi H. He's also absent today. I do
Why?
not have no information. So I just stand on Hagya.
Just cannot be casual like this. Next.
Yes, Jayadis. This Jayadis.
Are you in this case? Item 25. Your name is not there. You are not there. Neither the MS Doji, Learned Legal Aid Council, nor the PP represent additional PP representing the state are present. When the matter is followed. For hearing. Next paragraph. Mr. G. Other learned PP submits that its matter has been entrusted to MS El Hage learned additional PP. However, she has some personal difficulty. Is it? What is your ground? Why she is not appearing?
She may be out of station, out of town.
Do you have any information?
She may be because yesterday she told me she's supposed to going to Zero. I'm not sure, but yesterday but today she didn't inform me.
Thus, yesterday, MS El Hage learned additional PP has casually informed him that
Yes,
he would be going to Zero.
yes.
Other than that, he has no instruction.
No instruction.
Considering the conduct of the learned council for the parties, that is learned legal aid council as well as entrusted additional PP for the state. This court express its disappointment as the criminal appeal has been listed for hearing and non-represented or any instruction for any prayer for adjournment. List this matter after 2 weeks. On which date? On which? 2 weeks on, just fix the date. After 2 weeks. 2 weeks, huh? Just after 2 weeks, for hearing. On the next date, it is expected that the learned counsel for the parties, learned counsels are expected to adhere to the professional duties entrusted to them. Inform them.
Yes, I will inform them, both of them.